Okay, so Shannon is the Water Quality Director at the Conservation Commission and has been in that role since about 2007-ish. I've been working with her on various projects since then, and am interested to hear what she has to say about TMDLs. So welcome, Shannon.
Good morning. Well, as Jerry said, I do feel a little bit strange to be talking to you about TMDLs, given that you're going to hear from Mark Derschweiler later on today. Mark has really forgotten more about TMDLs than most of us will ever know, but I know just enough to be dangerous. So let's get started. I'm going to talk to you today about what TMDLs are and how they are working in Oklahoma, if I can figure out the technology. Yes, all right. So what is a TMDL? A TMDL is really an estimate of the maximum amount of a pollutant that a water body can safely assimilate. And by safely, we mean how much can it take in, process, and still meet water quality standards. And typically, given in the past, they've been estimated really as annualized loads rather than daily loads. But recent court cases have really recognized that difference in semantics, and so now more and more they are being expressed truly as daily loads. Thank you, lawyers. Because the tools that we have and the data that we have really does a better job of estimating what a safe annualized load is for a system. So the backbone of TMDLs and really of all of our water quality programs are water quality standards. And standards are really the tools that we have in place, the fundamental tool that we have in place to protect water quality. Standards define the goal for a water body based on a number of things. First of all, what is the best use of that water body? Is it best used for public and private drinking water supply? Is it best used for navigation? Also, then they set a number of criteria that are necessary to protect the support of that use. And then finally, they have provisions that allow for policies such as anti-degradation that further protect that water body. And in Oklahoma, standards are developed by the Oklahoma Water Resources Board. The Water Board works very cooperatively with a number of other state and federal agencies and stakeholders to do that. They're required to review their standards really every 3 years by EPA, but they do it almost every year. So standards are a continually evolving process for the state. Then the beneficial uses are really a classification that helps us to best assign what's the best, in the public interest, what's the best use for that water body. And for Oklahoma, the beneficial uses that we have assigned are public and private water supply, fish and wildlife propagation, agricultural uses such as irrigation or livestock water supply, navigation, aesthetics, because some water resources are valued for the fact that they are beautiful resources, and finally recreation. Now, each state is required for monitoring the status of its state's waters. And there are a number of agencies in Oklahoma that work cooperatively to do that. The Water Resources Board, the Conservation Commission, the DEQ, Department of Agriculture, and a number of other agencies all have monitoring programs that go out and look at streams, rivers, and lakes all across the state to determine whether or not they're meeting water quality standards. If they are not meeting water quality standards, then we report that to the Department of Environmental Quality, and those water bodies are placed on what's called the 303D list. And what happens as a consequence of being on the 303D list means that the state has to develop a TMDL or some other restoration plan that's going to define what steps we have to take in order to restore beneficial use support for that water body. So what do we have to do in order to make that water body meet water quality standards in the future? How long is it going to take? How much is it going to cost, et cetera, are all things to consider. So how is a TMDL developed? And there are numerous ways that TMDLs are calculated across the nation, but typically what is involved is that there's some sort of computer model that estimates or comes up with some facsimile of what the natural conditions are in that watershed and how they all integrate together to affect water quality downstream. We then use that model to estimate how much of the offending pollutant load reduction we have to reduce in order to meet water quality standards. We can also sometimes use that model to estimate how changes in management in the watershed might help us achieve that load reduction. So for instance, we might look at what happens if we change all the cultivated land, or the highly erodible cultivated land in a watershed, to pasture land. How does that affect loading? And is that a reasonable thing for us to do, for us to achieve the load reduction goals that the TMDL will set? So that process, the model development, allows us to set a number that we have to reach for load reduction goal. Then the next step is we really have to spread that goal out to a number of different sources in a fair way. So the next step in the process is called pollutant load allocation. And there are 4 primary components that you have to consider in pollutant load allocation. The first is how much of the load goes to the load allocation. And load allocations represent the non-point source portion of the loading. Non-point source pollution is really pollution that results from the runoff of rainfall or snow melt that washes pollutants off the surface of the land into water bodies. That's versus point source, or the waste load allocation, which is the result of loading from industrial facilities or wastewater treatment plants. And those are permitted facilities versus non-point source that's generally a non-permitted facility or load. Then finally, the other 2 things that you need to consider are, first of all, a margin of safety, which recognizes that this model or estimate of the watershed is just that, an estimate, not 100% representative of what the real processes are in the watershed, and so there's a margin of error to account for. And finally, there's a reserve capacity. It recognizes that in most watersheds, there will be growth that occurs, and so we need to allow for the fact that there could be future development in the watershed that can safely occur and yet still allow us to meet water quality standards. So that's the process that we assign fairly the resulting load to water bodies. And in Oklahoma, it's the Department of Environmental Quality that is responsible for developing both the 303D list and TMDLs. They do so in cooperation with state and federal agencies and stakeholders, but it really falls on their shoulders. And to this point, they have 84 water body segments where they have completed the required TMDLs. To put that in kind of the framework, though, and perspective, is that I think it's our 2012, which is our most currently approved 303D list. There's another 659 water body segments where we need to develop TMDLs. And some of those are in process, but many of those we need additional data in order to really develop the TMDL. Then beyond that, there's another almost 3,500 water body segments that we don't have enough data on to know whether or not they need a TMDL or not. We don't know whether they're supporting water quality standards or not. And to put that all in perspective, of our over 4,000 water body segments, there's one in the state that we know is meeting all of its beneficial uses. So I say all this to say that there has been a great deal of work that's been accomplished, but we have a tremendous need for additional monitoring in the state in order for us to really address these Clean Water Act requirements that require us to assess our waters and develop TMDLs for those that are not meeting water quality standards. So some TMDLs, I think one of the most important things would be to talk about how some specific TMDLs in the state, and some TMDLs are certainly more noteworthy and interesting than others. And one of those that is the most noteworthy right now is the Illinois River TMDL. And this TMDL is being developed because the Illinois River and Lake Tenkiller are violating water quality standards related to the fact that there's too many nutrients in the watershed. But given the fact that we have a volatile history with Arkansas, and that this watershed is shared between the states, Oklahoma recognized that if we were to develop a TMDL by ourselves, that Arkansas might not recognize or accept that TMDL was completely unbiased. And so we asked and worked with Arkansas for EPA headquarters to develop that TMDL and that model, hoping that that would result in a model and TMDL that was recognized as being less potentially biased, because we wouldn't have accepted one that Arkansas developed either, in all fairness. So, but you know, that is the least of the controversy related to this TMDL. It is, their EPA contractor has contracted with very reputable firms who are developing a separate model for the lake and for the watershed. to as accurately as possible depict the natural conditions. But there's been a great deal of back and forth about the quality of data available and recognition that regardless of how much information we have, we're never going to be able to really put down in a 3D computer model what actually happens in a watershed. And we don't have all the data that we would like to have the perfect model for such an important watershed. But the bulk of the controversy exists right now around the fact that although EPA contractors will have completed approved models by the end of this year, we have no process in place for what happens after that. And so there's we have no guarantee that an actual TMDL will be developed for this watershed. And that, if there is a TMDL developed, that it will include both water quality standards attainment in Illinois River and in Lake Tenkiller. And so those are processes that we all have to work through, and certainly the process of defining how that load allocation happens and the pollutant load allocation happens, that is really where the feathers are going to fly, and we don't know how that's going to happen at this point in time. So that's one interesting TMDL that's going on right now that puts a lot of pressure on the backs of DEQ. Another one that has been recently completed is the Lake Thunderbird TMDL, and that was developed by DEQ and approved by EPA towards the end of last year. And Thunderbird was impaired like many water supply lakes because it had too much algae growing in it caused by too many nutrients, but also it's earned its nickname of Dirty Bird, and it has excessive turbidity, which means there's a lot of suspended particles that affect clarity of the water. So this TMDL called for a 35% reduction in nutrients and in suspended solids. But the interesting thing about this watershed is that it is a highly urbanized watershed, although there are rural areas, but it's almost entirely incorporated. So even those rural areas are part of city boundaries. And that means that those city boundaries affect that affects their stormwater permits. There are permitted wastewater facilities, but there are no discharge facilities in this watershed, and so this is one of the few TMDLs that we have where the majority of the load reduction is going to have to come through changes in stormwater management. And we don't have many TMDLs like that in the state. So this one will be really interesting to watch how that is implemented and what those changes call for. Thankfully, it's a 35% reduction, whereas some of our other TMDLs have called for 85, 95% reductions. So with that, I'm just about out of time, and I will say that one of the things to answer with my talk was how are TMDLs working in Oklahoma? They really are working very well given the amount of resources that we have. I've shown you how much we don't know about the status of streams in the state. We have a aging infrastructure that's causing our discharge and our treatment plants to always be in need of upgrade. And so given the resources that we have available to us, we're doing a really good job, but obviously we could do better if we had more. All right.
We'll save questions. We'll save questions until right before lunch, and then if you have questions for any of the panel, hopefully we'll have time to take a few and get those answered. I will say this, her having talked about TMDLs, when I was working on the water plan, we were having a meeting, and I think there was a lot of talk about TMDLs at this particular meeting, and afterwards we were going around cleaning up, and I found a napkin, which I probably still have laying on a table, and it said TMDL, too many damn lawyers. So, you know, it might mean total maximum daily load, or it might mean the other sometimes. Our next speaker is Tina Gunter, who works at the Department of Ag, Food, and Forestry, and she's going to talk about the agriculture pollution discharge elimination system permitting. DEQ does it for municipalities and industry, and Ag is now doing some of it in the agriculture sector. I think I found it. All right, so let's welcome Tina.
Good morning. I apologize. I don't have as pretty of a PowerPoint as everyone else will. I don't do pictures. I don't do any of that stuff. I'm lucky I got a PowerPoint together. I don't know why. I'd rather just talk. So, but anyway, the Department of Agriculture, we've got relatively a new program, and I don't know which button to push.
Zero.
I'll push. That's what I was thinking. Yeah, that's easier. The Department of Agriculture, we only recently received the program to do Clean Water Act programs. Basically, DEQ in the state has had authority to operate Clean Water Act permits for municipalities and for industrial sources for, since the 90s, I know for sure, probably before that. Anyway, so they've been doing it for a very long time. But the way the environmental jurisdiction is set up in Oklahoma, all of the agricultural things were held for the Department of Agriculture. So what that meant is, in this state, if you had an agricultural type of permit that you needed that was a Clean Water Act permit, you had to go to EPA Region 6 to get that permit, rather than going to DEQ. And so it took us a very long time, but over the course of about 10, maybe longer, probably 15 years, the Department of Ag kind of endeavored to try to obtain the authorization to operate those Clean Water Act programs that involved agriculture. And we finally, and I say finally, because the last time I spoke to this group was in Oklahoma City when we thought we were going to have the program by then, and we were still fighting over words in the documents that we were providing to EPA. It turned out to be a really arduous process that we argued over literally every single word in the document, it seemed like, throughout the process. So, but we did finally obtain it on December 20th of 2012. So we've had the program roughly a year now. And and what that involves, and some of you that are maybe familiar with the Department of Ag, we have a lot of environmental programs that are state environmental programs. We have a CAFO licensing program. We have poultry registration programs. We've got pesticide programs. We've got all kinds of programs already on the books. But by adding the Clean Water Act segment to it, it basically means that if a producer needs to get a CAFO permit, he doesn't have to go to us and to EPA Region 6 to do that. He can come to us, and he's dealing with the same folks to take care of that. And so that was one of the benefits to doing it in the state and trying to get it at our agency. A lot of people say agriculture is not necessarily an environmental agency. First of all, we are by statute. And second of all, we're a lot more environmental than most people know. Most people only know us by our happy programs, is what I call them, our Made in Oklahoma programs and our wonderful marketing programs. Of about 500 employees at the agency, that involves about 15 employees. The rest of us are all doing other stuff, regulatory work and such as that, so which does come as a surprise to a lot of people. So, but right now, since we've received that authorization to operate we call it Ag PDES, made up name. The Oklahoma has the OPDES. It's all the Oklahoma Pollutant Discharge Elimination System. We call ours the Agriculture Pollutant Discharge Elimination System because we needed something that set it apart. So anyway, so we went through all of that process, and currently we have the authority to issue 3 general permits. All of these permits were not developed by Department of Ag. They were all permits that were developed by EPA that we just took over whenever we took over the program. So none of them were actually developed by us. They went through all of the process of being developed through EPA's processes. And so when they expire, then it'll be our turn, which will be brand new ground for us also in developing those permits. So, but currently we issue 3 general permits. One of those is the CAFO general permit, Concentrated Animal Feeding Operations, and that's there was a new permit issued, a new general permit issued by EPA back. I think it went into effect back in February or so of last year. So it's still a relatively new permit. We had an old permit called that was a CAFO permit that was actually issued in '93, and as many of you that are familiar with permitting know that permits are good for 5 years, but it took EPA until last year to actually replace that '93 permit. And my favorite term that I've ever heard in my entire life that EPA uses is that it's expired, because it expires in 5 years, but continuing. And I love that. It's expired but continuing. It makes perfect sense. So anyway, so the permit that we're working on right now is we're really issuing, we're working on issuing general permits to CAFOs who were operating under the old permit for all of this time, and now they're trying to get up to snuff on the new permit. And there's some significant changes, both procedurally and in the actual permit itself. One of the other permits we're doing is a brand new permit. It's the pesticide general permit. There had never been a pesticide general permit through the NPDES program. All of the pesticide stuff had previously been run through FIFRA and through that aspects of EPA programs. And our department has for years operated many of the inspections and the enforcement on behalf of EPA for the pesticide aspects. But that dealt with licensing of applicators. That dealt with the products themselves and those sorts of things. But a few years back, there was several court cases that came up about applications of pesticides to aquatic sources and whether those should also be covered by a Clean Water Act program, Clean Water Act permit. And so that's what we have now in place. The stormwater also is another area, because we have the stormwater construction permit operated by DEQ, but if you were an agricultural site, if you were disturbing enough acreage and you were building a CAFO, for example, or a poultry facility or other types of agricultural sites, you had to go to EPA Region 6 to obtain that permit. And so that permit also now is housed with the Department of Agriculture. Again, it's only for agricultural activities. And then any of those activities that if someone comes in and needs a permit and they don't fit the criteria of the general permit, then we're responsible also for issuing individual permits on case-by-case basis, depending on what may come up. So the CAFO permit, like I said, that general permit became effective February 1st of 2012. The process for obtaining that permit is a little bit different. Actually, it's a lot different from what it was originally. Under the old scheme, you file your notice of intent, you go through the process, you get your authorization, and you operate under that general permit, and you deal with everything for all of your inspections and such as that. But it was more of a producer and EPA at the time, or producer and agency interaction. A court case came up back in, and I don't remember the year anymore, it's been a little while, where now there was a concern about public notice of what's in those CAFO permits, and primarily the nutrient management plan. The nutrient management plan is what you would say is pretty much the operating criteria for the facility. How they're going to manage their waste. Are they going to land apply it? Do they have a total evaporative system? What are they doing to manage that waste, and how are they going to do that? Previously, under the federal program, that was a document that they put together. They kept on site. It could be checked by EPA, and they worked with them on that. But it was not a document that was sent out for public notice. It wasn't a document that ended up not even necessarily ended up in the office of EPA at that time. Well, that's completely different now. Now, the nutrient management plan has to be submitted along with the notice of intent, and it's reviewed by our department staff, and we review it very extensively. And then the next step is it goes out for public comment and public notice and a comment period. So there's a lot more involved in the process than there used to be as far as if you're a CAFO permit. Now, for our Oklahoma CAFOs, in a lot of states, this is a huge deal, okay? Because in a lot of states, the state program didn't require any documents submitted either. So no one's ever seen nutrient management plans, or animal waste management plans was the old terminology for those types of facilities. But in Oklahoma, if you were licensed as a state licensed CAFO, you had to submit all that stuff to us anyway. All of that stuff came to the office. We didn't have a general permit that was an expedited method. Everything was, I've always equated everything we did on a state permit was just like an individual permit. It was a much more extensive process. We review every single document. We review every aspect of it, and there's more plans to it than even just the nutrient management plan in the state program. So if you were an Oklahoma CAFO and you got a license from us, your materials were already in our files, so you were already subject to the Oklahoma Open Records Act. And so most people are used to that being part of the process. Now, and they also had to go through public notice. They had to go through notice by publication and individual notice to landowners within a mile up to 2 miles in some cases to be able to request hearings and all that sort of thing on the state program. So for Oklahoma CAFOs, this is not as big of a leap as it is in some other states. Some other states, the industry has just gone nuts over having to provide all this stuff. They don't want people in their business. They don't want people seeing their daily operational plans and that sort of thing. But I think in Oklahoma that's been tempered quite a bit just because of the state program that we've had in place for so long. So anyway, so the next step is they then go to public notice and comment period, but that doesn't happen until after the Department of Ag has reviewed their nutrient management plan, requested any changes we think are necessary to it, and I can say from experience we always have changes we think are necessary. Never have received a perfect one yet. We're still waiting on the perfect one to show up, but we haven't seen it yet. And then the next aspect of that process is we provide a response to any comments that we do receive. And by the way, public notice and comment is a lot of it is done online these days. And so, and that's one of the things we have recently put together is our method for putting some out on public notice. And in fact, yesterday was the very first time any of them actually went out on public notice. They haven't been to our website yet. I've got the website listing in here if you want to go look at them. It's on one of the back pages here, but we're not sure how that's going to go. This is kind of a new process for us doing it with the online method and that thing. So, but once we get the comments, we get the response to comments, and then there's written notification of whether they have received their authorization to operate under that general permit or if it's denied, and go from there. So, and I'll point out that a lot of these, the facilities that are all applying for these things, they're all existing facilities. We haven't seen any new facilities coming into the state. We don't have very many new dairies, new swine operations, new cattle beef feedlot operations coming into the state. Most of them are people that were already licensed under the old scheme. Most of them also have a state license. So it's something that we're very familiar with these particular facilities. The next one, like I said, the pesticide journal permit is kind of a new thing around. It's been out probably a couple of years at this point in time, and it's very, very specific as to what it covers. It doesn't cover all pesticide applications. It doesn't cover pesticide applications of every cropland, everything, anything like that. It primarily is covering where it's likely that the application is either to waters of the state for things like weed and algae control, which was actually the court case that came up. That was the circumstance that came up. It was a application for weed and algae control in an irrigation ditch. I think it was Oregon and Washington, northwest part of the country. And then they also have mosquito and other insect pest control, maybe an aspect of that. There may be some animal pest controls also. And then where we see it in southeast Oklahoma is forest canopy pest control as well. So those are relatively limited circumstances in Oklahoma that we see those, because first of all, in western Oklahoma, there's not a lot of water to apply to. So it's you don't tend to see a lot of this. But what we do see primarily getting that permit are a lot of municipalities and utility companies and timber companies, because they're the ones, municipalities are the ones that are concerned about mosquito and other insect pest control a lot of times. Weed and algae control is definitely utilities very often are concerned about that. We have an irrigation district that's also involved in that. And then the forest canopy is obviously the forest companies that we've got down in the southeast part of the state. Stormwater general permit, it works just like the stormwater permit for everybody else. It's not, there's nothing unique, I guess, about that particular permit, except that ag issues it if it's an ag type operation. Works the same way as what Mark will be talking about. So, but it's construction activities on agricultural sites. That's primarily what we deal with. They file the notice of intent. They put together their stormwater pollution prevention plan. And the next step on that is if once the construction is completed, they're required to file a notice of termination to complete that process. Individual permits, we don't have any of those pending out there right now. But if we did, then generally we've got a form that they'd fill out. It's a little bit more extensive. It would be a lot more akin to what's being done on some of the larger industrial sites by DEQ. It'd be the similar process. Just in case you aren't familiar with the law that we've put together on this, I copied DEQ when I wrote it. It was the easiest way. I figured, why reinvent the wheel? I looked at all their stuff, and so if you ever look at our law in Title II and compare it to 27A, you're going to see that it's very often verbatim to it, except we change ag in for DEQ and stuff like that. So, so we copied their processes. So so the processes are very, very similar. And they were intentional that way. We didn't want to reinvent something whenever we had a process that was out there that was working. So, but maybe a draft fact sheet involved in an individual permit, proposed permit would go out, then it would go out on public notice, 30-day public period, response to comments, written approval or denial. There's opportunities for hearings on this, and in this aspect, there's opportunities for full-blown hearings that can end up in district court and such as that. So that's the more extensive aspect of the individuals. Right now, as of yesterday, we have 3 CAFO general permits out for public notice, and those are the first 3 we've put out. Like I say, we've had this program since December of 2012. But so far, we're not satisfied with the rest of the nutrient management plans. We're still working. We're still doing the give and take process of getting those up to snuff. We've got the 3 that are out for public notice are actually all owned by the same individual, and he got all of his together, and so we've put those out as of yesterday. So we're, for the first time, have some of those out for public comment and get to see how that process is going to work under the general permit. Right now, we have about 20 pesticide general permits out there. Like I say, primarily municipalities, a few utility companies and forest companies. And we only have 4 stormwater general permits out there. I will say that we have people that are still learning that they need a stormwater general permit out there, because I'm fairly confident there should be more than 4. And so we're working on a lot of education in that aspect of it and what's required to complete that process. And as I said, we don't have any individual permits pending or available out there right now. This is just a quick reference to, because I think I'm almost out, quick reference to our statutory scheme. We have the Oklahoma Agriculture Pollutant Discharge Elimination Act, System Act, I think I left a word out there, but that's found in Title II, beginning at Section 2A-1. And then we also have the Oklahoma Environmental Permitting Act, which starts at 2A-21 in Title II as well. Again, you're going to see that those track the DEQ OPDES programs and their Environmental Permitting Act very, very closely, if not almost verbatim. There's a few tweaks here and there simply because some of the things we do are a little bit different than theirs, but that's there. Then all of our rules are found in Title 35 and Chapter 44, and that's our Ag PDS title in that. One of the major differences that we have, that we've had to have as far as our scheme goes, that's completely different from DEQ is, as you know, DEQ's executive director is the person that is the final say on permits and delegates the authority maybe on some other things, but that's the final say. Department of Ag, one of our big issues during the process was, from EPA's standpoint, it's a conflict of interest. If you have if your person that's issuing those permits is also a member of the industry. Well, by state constitution, our commissioner has to be a member of industry. So, and all of our State Board of Agriculture members must be farmers, and so they are members of industry. So we had to, part of what you'll see that's different from the DEQ regs is we had to create a separate position in the agency called the Ag PDES Director, and that position is not the top position. It's appointed by the commissioner, but it is not actually our executive director or our commissioner. It's actually another person in the agency that handles that. And so that's kind of created a little bit of confusion for some folks, but we had to do that, and we had to draft our scheme in order to make the conflict of interest requirements that EPA had on us. So, contact information, if you've got questions, be happy to answer them. And that bottom citation, that bottom link there is also to our Ag PDES program. So go look at it, and I'm curious. I haven't actually had a chance to look and see how it's working yet either. So see how that looks. Thank y'all.
Thanks a lot, Tina. All right. Our next speaker, Sarah Gibson. She was formerly with DEQ, and about 6 or 8 months ago went over to the Water Resources Board after Dean Couch finally gave it up and retired into private practice, and is probably as busy or busier now than he was when he was at the Water Board. But we appreciate Sarah coming over here, and she's going to talk a little bit about the impact of House Bill 2055. Thanks, Sarah.
Okay, I know rulemaking is the #1 reason you all are here today, everybody's favorite topic, but there were some really interesting changes that happened last year. So if you have interest in administrative law in any way, I hope this presentation will interest you somewhat. During the 2013 legislative session, the Oklahoma legislature enacted House Bill 2055. I will admit that I knew that bill had been out there. It was on the tracking list for all the agencies. I did not pay attention to what they were doing in that bill until it was time to start the rulemaking process for this legislative session. And I learned that House Bill 2055 made some significant changes to the rulemaking provisions of the Oklahoma Administrative Procedures Act. Following the enactment of this bill, as a result of this bill, the governor made additional changes to the rulemaking process through Executive Order 2013-34. This presentation is going to give a brief overview of the changes to the process, and we'll talk about some potential impacts of the changes. This presentation is geared only toward permanent rulemaking. House Bill 2055 made some changes to the emergency rulemaking process, the most important of which is changing the expiration date of emergency rules from July 14th of the following year to September 14th. So it gives agencies a little more room to operate. This chart shows the milestones in the rulemaking process. I don't know if you can see the highlighted ones on there, but they represent the parts of the process that were impacted by 2055 in the executive order. The changes to the process affect all the parts of rulemaking, but this will give you some idea of where we're going in this presentation. So we'll start with the Notice of Rulemaking Intent. The Notice of Rulemaking Intent is designed to give interested parties notice that certain rules are going to be amended, added, or deleted. The notice also advises interested parties of the date the rule text will be available, which is usually the day the notice is published in the Oklahoma Register, and the dates for the public comment period that usually lasts 30 days. House Bill 2055 did not change the requirements for the notice, but took some other action that led to the issuance of the executive order that did affect the Notice of Rulemaking Intent. So House Bill 2055 repealed Title 75, Section 303.2, and this was the section that contained the provisions for gubernatorial review. The 5 days that the governor had to review any rules post-adoption by the agency. The governor was apparently not very happy about this action and issued Executive Order 2013-34, which does not change the requirements of the notice, but uses it as a trigger for a new kind of gubernatorial review. So the pertinent parts of the executive order says that the text of the rule must be submitted to the governor and the appropriate cabinet secretary when a notice of rulemaking intent is submitted to the Office of Administrative Rules. This is usually 15 days or so before the notice is actually published in the Register. The most interesting part to me is the executive order also said that no agency may adopt a proposed permanent rule within 45 days of providing the proposed rule to the governor's office. This is certainly an interesting change. Previously, there had been no pre-adoption review and certainly no process that would stop an agency from adopting a rule. And the governor can actively disapprove a rule by providing express written disapproval, citing the reasons for disapproval, or the 45 days expires and the agency can proceed with adoption. So I will talk about the impacts of that a little bit later. I thought this pre-adoption review would affect agency timelines more than it turned out for the Water Resources Board anyway than it did. If you are an agency that uses the 15 days between submission and publication to tweak your rules or finalize language, that is eliminated and your rules must be ready for review when you submit the notice of rulemaking intent. I missed that 15 days this year. Now, the legislative changes to the Administrative Procedures Act in House Bill 2055 are interesting and a little bit confusing. The first change that it made, not the first, it amends the rule promulgation provisions of the APA. So the April 1st deadline remains the same. If you submit your rules to the legislature by April 1st, the legislature must act on those rules during the current session. They changed the way they must act in 2055 by there's no more silent approval by the legislature. They must actively approve or disapprove any rule by joint resolution. And instead of having a 30 legislative day timeline, they have until the last day of the regular legislative session to review and act upon the proposed rules. Legislative approval or disapproval is accomplished only by joint resolution. Joint resolutions for the purposes of rulemaking are not subject to regular legislative cutoff dates, which means you probably won't see any rulemaking joint resolutions in a committee meeting. And because it would be cumbersome, to say the least, to do a separate joint resolution for each rulemaking action, 2055 introduced the idea of the omnibus joint resolution. I know this slide breaks every rule of PowerPoint presentations. Now, I apologize, but subsection D is, I don't even know what it is, but you need all those parts, and so I wanted you to be able to have that all in one place. So the omnibus joint resolution will be prepared each session and will contain the language that all proposed permanent rules of state agencies filed before April 1st are approved except for the listed rules that they are disapproving. The indication we seem to be getting from people in the legislature, people in the governor's Office of Administrative Rules, is that the legislature will use the omnibus joint resolution to attempt to pass rules that will almost certainly depend on what kinds of rules they're seeing, and if the legislature agrees on what should pass and what shouldn't, which we'll see what happens there. But they, again, can break those rules out and send them through in separate joint resolutions. We'll just have to see how that plays out. So after the passage of the omnibus joint resolution, the governor may sign or veto the joint resolution, which would be the ideal situation, but she would sign it. The rules are finally adopted, and everybody goes along. Subsection D provides two other methods other than veto for the governor to override legislative disapproval. The first of which, if an agency rule is disapproved, the agency can petition the governor through the process listed in subsection D for stating the necessity of the rule and its authority to make the rule. And if the governor agrees, then she can declare the rule to be approved and finally adopted by publishing the declaration in the Oklahoma Register. And then this subsection 4, if the omnibus joint resolution fails to pass both houses and be signed by the governor, or is found to have a technical legal defect preventing approval, then she may declare all rules to be approved and finally adopted, again by publication in the Oklahoma Register. Potential impacts. Like I said, I think when the executive order was issued, a lot of agencies got really nervous really quickly about how that would affect their rulemaking timelines, internal rule development. It works out that usually the timeline from the submission of your notice for publication and the end of your 30-day comment period is about 45 days. So as long as the governor doesn't have any issues with your rules, then I don't really see that to have a huge impact. Energy Environment is very lucky to have a cabinet secretary who is informed of all the issues and works well with each of his agencies, which is a bonus to our agencies during this process. One disapproval by the governor or cabinet secretary during initial review. One question that leads to, is there any way to proceed with a proposed rulemaking? That would be an interesting challenge to see play out, whether or not the governor has adequate authority to prevent an agency entirely from proceeding with rulemaking before it's even noticed the proposed rules. Agencies will have the additional burden of tracking their rules through the legislative process, making sure their rules are included in the joint resolution, making sure they're not on the list for disapproval, or taking whatever actions are necessary to make sure an individual joint resolution is passed. And this is the problem that the Office of Administrative Rules has already stated is going to occur. Promulgation of the finally adopted rules when omnibus resolution is used. Previously, agency rules were finally adopted on different dates throughout the session. So they were published in different versions of the Oklahoma Register. If they use the joint or the omnibus joint resolution, all agency rules will be finally adopted on the same day. Also, all agency rules will go for publication and promulgation at the same time. The Office of Administrative Rules has already stated they can't handle that kind of workload to get everything in the same version of the register. So the effective date of the rules is going to depend on which version of the register your rules make it into, and the Office of Administrative Rules said they're just going to take the first bunch that comes in and the next bunch that comes in. So you may want to check any rules that you're watching this year for the appropriate effective date. So that's all I have. I'll be happy to take any questions whenever Jerry says it's time. Thank you.
Thanks, Sarah. All right. Our final speaker of the morning session is Mark Dirkschweiler, and actually he was the first speaker we got to commit. Jason and I decided to do this standing at a reception at the Governor's Water Conference last October, and poor Mark just happened to be standing there as well. And we sort of convinced him that this would be a good idea to do, and he graciously accepted, so we certainly appreciate that. Mark is the engineering manager for DEQ and has worked there for several years, and as Shannon said, we've all probably forgotten more than he's probably forgotten more than most of us know about stormwater and permitting. So Mark Dirkschweiler.
Thank you, Jerry. I appreciate the invitation, the opportunity to be here, because if there's one thing I've learned, it's that lawyers need education by engineers. Now, I've always heard that attorneys didn't know much about math, but Jason figured out that I have 29 slides in less than 15 minutes right before lunch. So we've deduced that I'm going to have to skip through some of this pretty quickly, so I apologize for that in advance. But I'm going to give sort of a brief overview of the stormwater program in Oklahoma, and then focus on the program for MS4s, Municipal Separate Storm Sewer Systems, cities and towns around the state. But first of all, why are we even doing this? Shannon talked about some of the impaired streams in the state, and in other studies all around the country, stormwater has been identified as a source of impairment in lots of waters everywhere. Things like sediment, floatables, oil and grease, toxics, and other things that we've seen even in the Lake Thunderbird study, which is dominated by stormwater discharges. Most of the people in this country live in an urbanized area, and most of the people that are coming in the future are going to be living in those areas. People produce pollution, and stormwater is the main unregulated source at the time this program was started that was left. And as far as construction sites, anybody that's seen a construction site where they brought in the bulldozers and stripped off all the vegetation over a large area, I think everybody understands that the erosion from those kinds of places are a lot higher than any place else. And just a few pictures of things that we've seen around the state. There's a salvage yard. That's one of the regulated industries in the industrial program. There's a wood processing facility on the top there. The two pictures on the bottom are from a garbage generator in a large town in northeast Oklahoma, not to mention any names. That's also a regulated sector in the industrial program. And some examples of things from construction sites where debris has just been dumped in the little drainage way there. Somebody tried to put up some silt fencing around to stop the sediment, but you have to take care of those for them to work, and then you can see some sort of graphic examples of the kind of sediment that gets carried off in stormwater from some construction sites. This graphic shows sort of what happens as land use moves from open area to cities and towns. And generally, what happens is we increase the imperviousness, the amount of streets and parking lots and roofs in an area. The amount of water that evaporates into the air and the amount of water that infiltrates into the ground goes way down. And at the same time, the amount of water that runs off of that area goes way up. It's the same amount of water that falls there, and it all has to go somewhere. So the water that was going into the ground and into the air now runs off into the stream. And on the right side there, you can see sort of what happens. You get what they call flashy conditions. You get large increases in the amount of water that flows over a short period of time. High-intensity flooding events that don't last very long because there's so much water that comes off of the concrete. That changes the creek. It changes the way, just the physical characteristics of the sinuosity and the way the creek curves around. It erodes the banks away. It erodes the sediment on the bed of the creek. And that has effects on the fish and the other wildlife in the aquatic community. And those are not good effects. Just a bit of a history of the program. The Clean Water Act was originally amended back in 1987 to address stormwater. Phase 1, of course, came before Phase 2. Phase 1 dealt with the larger cities and towns. We have two communities here in Oklahoma, Oklahoma City and Tulsa, that are regulated in Phase 1, and I'm really not going to say anything about them. So the first interim regulations on Phase 2 came out in '95. You can see some of the other dates there. One of sort of particular importance in 1996, the major point source, sewage treatment plants, industrial facilities, parts of the permitting program were delegated to DEQ. In September of 1997, we got authority over the stormwater program. So we've been operating the program since 1997. Phase 1 was the larger communities, the same set of industries that we regulate now, and the threshold for construction sites back then was 5 acres. The Phase 2 regulations came out in 1999. That brought in the small municipal separate storm sewer systems. It dropped the threshold for construction sites from 5 acres down to 1 acre, and allowed for any additional activities that were causing a problem to be designated by the permitting authority. This is the so-called residual designation authority, which you may hear something about in the legal literature, because there are petitions in the New England states right now where some of the environmental groups up there, mainly around the Chesapeake Bay and some other things, petitioning EPA and some of the states to designate additional stormwater sources that are not regulated directly through the statute, things like large parking lots at shopping centers and things like that. Okay, so for you, the lawyers in the crowd, here are the relevant citations in the Clean Water Act and the rules in the 40 CFR. Other than some minor procedural rules about permit issuance, we've adopted these rules by reference, so the federal rules really are what we go by to operate the program. Just an outline of sort of how this all fits in. The Clean Water Act set up the National Pollutant Discharge Elimination System, NPDES for us, AgPDES for them, OPDES, specific for Oklahoma. Stormwater is a part of that. So stormwater, even though it's driven by rainfall events, which normally are called a non-point source because it runs off of the land, it does go through the storm sewer system and eventually comes out of pipe. So they're regulated as point sources in the Clean Water Act. And there's 3 parts: the construction sites, the industries, and the municipalities. So where we are in Oklahoma with our permitting program, we're in our 3rd version of our construction permit. It's permit number OKR 10. The last one of those was issued in September of 2012. It's good for 5 years. The number of permittees that we have on these, of course, fluctuates from day to day even, but the last time I checked, we had 1,363 active permits, and 170 more that were under review. The industrial permit, similar, that was issued in 2011, good for 5 years, about the same number of active permittees. The small communities and the Phase 2 MS4 program, that permit has been expired since February of 2010. We've been doing some outreach with the communities and working sort of off and on getting the permit drafted. But it has been submitted to EPA. They have a time period to review any of our permits under the delegation agreement that we have, and their time runs out next week. So I expect we'll be getting comments next week. We have 43 permittees under that permit. So how do you get into the Phase 2 MS4 program? There's essentially 3 ways. First, the Census Bureau defines what they call urbanized areas, and these are intensely developed areas that are connected to a core municipality. So the core municipalities in Oklahoma are Oklahoma City, Tulsa, Lawton. Norman was split off last time, and we also have part of Fort Smith that lops over into Oklahoma. So if you're within an urbanized area, communities that have portions of their city boundaries in an urbanized area are automatically in the program. Although there are some waivers, and we've tried to make liberal use of those as much as possible. Counties can also be designated. If there is unincorporated territory within the urbanized area, the county then is responsible for the program in those areas. There are also some of those that are eligible for waivers. Outside of these urbanized areas, any community above 10,000 population that has a population density of 1,000 people per square mile or greater has to be evaluated. And we developed a sort of a point-based ranking system that we used for that. Here are the communities that went through the process. The ones on the left side there are the ones around Tulsa. The ones in the tan yellow color are the communities around Oklahoma City. Arcoma, Moffett, and Pensacola are the 3 that are connected to Fort Smith over on the state line, and then Lawton. The asterisks here are the ones that in the first permit 7 years ago we were able to grant a waiver. So all of the ones around Fort Smith. Has anybody been to Moffett? No. Has anybody been to Smith Village? So these are Smith Village is like 2 blocks by 3 blocks. They operate a big flea market in southeastern Oklahoma City. They really have no local government, so we've tried to give waivers to those kinds of people. These are the counties that were evaluated in the original program, and there are several that ended up needing to get a permit. Again, the ones with the asterisk here were able to qualify for a waiver. These are the communities above 10,000 population that we looked at. The ones with the star here ended up getting a permit. The ones that have no indicator there did not pass the 1,000 people per square mile test. And Guyman was one that got a waiver there. So how does the program work? It's built around a stormwater management program that each community develops. The technology-based requirement here is reducing discharges to the maximum extent practicable. That's the statutory term. It's not really defined anywhere. And communities then develop their own program. They have to look at these 6 areas, and each one of these has to be addressed with some kind of a quantitative program that's summarized in an annual report. This is a little different from your typical discharge permit because there are no effluent limits. This is all based on developing management measures that are tied to those 6 areas that we just looked at. So what's coming up in the near future? Just a brief summary of some of the changes, the major changes we're making in the proposed permit that EPA is looking at. There are some additional permittees that no longer qualify for the waiver, and some of the urbanized area boundaries have expanded. So these 8 people will be getting a permit that don't currently have one. EPA, thanks to lawyers again, is very skittish about discharges into impaired waters. They've been sued numerous times, and they've lost just about every case that's been filed related to discharges into impaired waters. And they are really interested in what we've put in the permit. I expect this is one area where we're going to get comments. We have added language that before the TMDL is done, some measures need to be targeted towards addressing those impairments, even though the TMDL is not done. If it is done and there's a waste load allocation in the TMDL, like Norman, Moore, Oklahoma City, and Thunderbird, that has to become a part of the management plan. We're proposing to expand the jurisdiction. The way it works right now for these cities that have urbanized area within their boundaries, but it's not the entire corporate boundary of the city, they only have to operate the program in the urbanized area, not the entire city. This is something that EPA is looking at nationally that we've supported mostly, and we're proposing to change that so that the program applies to the entire community. And there are some new technology requirements for construction sites that's already included in our construction program. We allow cities to use this MS4 permit to cover their own construction projects so they don't have to go get that construction permit. We're also, along with EPA and just about everybody else in the country, promoting low-impact development or green infrastructure approaches. And we have added a provision there for these communities to evaluate their local requirements to identify barriers. We're not telling people that they have to do this, but we are asking that they look at things that prevent developers that want to do these things from doing them and remove those as much as possible. Here's some of the EPA websites if you're interested in these things, some of the types of approaches that can be done. There's a parking lot retention basin. I know OSU's done some research on these in Oklahoma. There's a bump out rain garden up there on the top and a grassed swale. So these are the kinds of things that we're supporting and promoting. EPA is also undertaking a rulemaking to change the stormwater program and expand it. And again, a lot of this is coming out of litigation around the Chesapeake Bay, TMDL, and the activities going on up there. So they're looking at expanding the scope of the program, looking at more construction requirements and some other things you can see there. So I think we're just almost on time. Thanks, Jerry.
Thanks, Mark. I would be remiss, because one of my bosses is sitting here. The stormwater and non-point source pollution is kind of part of my job. We do outreach and education through the Blue Thumb program. We work with, for example, I'm working with the City of Stillwater and a children's museum right now to go in and do some education about watershed models. And what I have found as we've gone out and done this education is, first of all, how many adults don't know what a watershed is? And second of all, mostly kids, but even adults, you ask them when the water goes down the storm drain, where does it go? And they often say, well, to the sewer. And then we explain to them that no, it goes directly into a creek. And so just getting out there and educating, which is what a lot of the smaller cities, it's all they have. And so we try to work a lot with the smaller cities to help them provide that education to their citizens about non-point source pollution and runoff, and that's kind of my soapbox thing. Although the last thing I'll say is there's a whole group of 5th graders out of Okmulgee who don't want to drink water anymore because they learned that wastewater gets dumped back into the river upstream, and it kind of grossed them out. So I kind of had to apologize to them.
I want to introduce the folks on our panel, which is my job at this point in time. And so I'm going to start here with David Levitt. Now, it was a revelation to me that David and I had actually gone to law school together. I'd been emailing with David for 2 months, putting this presentation together. We talked back and forth and by email, and then I see his face, and I'm like, oh my goodness, I know you. So it's lovely. Now, David is an administrative law judge at the Oklahoma Corporation Commission. For any of you who may have appeared before him or may not have, a graduate here of our University of Tulsa Law School. He's previously held positions at the Oklahoma Department of Agriculture, Food, and Forestry, where he's the Director of Administrative Services and the Assistant General Counsel. David has also practiced civil law and served as the Director of Commercial Development for the Oklahoma Technology Commercialization Center, now known as I2E, amongst a number of other things. And you can see David's bio in your materials. Next to David is Mark Seacrest, and I have to say that I've had the really good fortune to have the opportunity to have Mark as general counsel of an agency where I was appearing on behalf of a client before that agency. And that agency is the Oklahoma Department of Mines, where Mark's the general counsel and has been the general counsel since 1987, which is, I think, when I graduated from college. I guess I shouldn't say that. Anyway, before that, believe it or not, Mark served as the Assistant General Counsel for Turner Brothers, a coal mining company in Muskogee, and he worked for a law firm in Tulsa, Wilburn, Knowles, and King. There have been some really interesting lawsuits that have gone through the mining department over the years, including recently, and Mark's been responsible for them, and he's a wealth of knowledge and information. So if you're kind of thinking about some environmental litigation or some agency litigation, Mark's always, I know, been kind to everyone working with him or before the agency to talk and spend some time and to think about things. Now, Ed Feit. Ed Feit has probably, and ironically, the shortest bio in our and Ed, that was no slight. This is what you find when you go on the Oklahoma Water Resources Board's webpage and you look for Ed Feit, where Ed is on the board at the Oklahoma Water Resources Board and has been for many years. I've had the great fortune of appearing before Ed when he was on the board there and continues to be, and listening to the arguments that the board has. You know, there was a decision by the Oklahoma Supreme Court recently, a few years ago, that said that the board actually, these different state boards actually have to consider the decisions that they make. And I can tell you that in my experience appearing before your agency, you guys as a board actually do. And I've seen you do that quite often. Ed's also the administrator for the Oklahoma Scenic Rivers Commission, and as we all know, has an enormous passion for the Illinois River, for wild places, for the preservation of our state. There's a service there that Ed's provided to our community and to future generations that can't be possibly overstated. Now, we have over on this side here Dr. Daryl Townsend. I think, Daryl, you might be the only doctor we've got on the group. And I'm glad about that. Daryl is the Assistant General Manager for Ecosystem and Lake Management. You know, I didn't know you at all, Daryl, before we put this panel together and Jerry introduced me to you, but I'm absolutely thrilled to learn about your position and the way that the GRDA takes a very important aspect of managing the natural resources associated with the lake and the concept of ecosystem management, and that is your job. I don't think folks really, I certainly, maybe I'm just ignorant, but I didn't really know that the agency did that or that you had that role to play and to serve.
Yeah, you know, the agency was created as a conservation and reclamation district for the waters of the Grand River, and a lot of people don't understand that, and quite frankly, it has been really ignored essentially by the agency until about 2004. And so since that time, I was hired by the agency to renew the focus of these issues, conservation, restoration issues, watershed issues, for the authority to meet that purpose of the enabling legislation. And so we felt like we've done that, and felt like we've come quite a ways in 10 short years since the creation of that department. Thank you.
It's an amazingly important function, and it's brilliant that the agency's doing it. Thank you for doing that. The last person on our panel is going to be the first person to start out our direction, and it's Professor Melissa Luttrell, who's become a friend of mine. Melissa is new here to Oklahoma, and so I thought about what we were doing, and I have to tell you that I crafted a question, the 9th question. Melissa crafted the 10th one. And we crafted these questions. I crafted this question with the idea of introducing you to Melissa, to introducing our legal community in Oklahoma here, because Melissa's area of specialty and her expertise is in addressing some of these questions relating to environmental decision-making, environmental risk assessment, whether or not it's right or wrong, should be applied or shouldn't be applied, when it should, when it shouldn't, and is a real resource for all of us that practice in the state. And so the rest of the questions are all free-for-all, essentially. In other words, the folks up here on the panel are primarily responsible for kind of deciding after question 9 which question we address. So though you're welcome to shout out and say, no, let's really hit that question of whether or not there's a public trust over water in Oklahoma. But this is supposed to be a discussion between all of us. So Melissa's going to lead that, and then one of the rest of you are going to take another question. Let's try and spend about 15 minutes on a question or so, and then move on and see, when we're all really tired of arguing with each other. So with that, thank you very much. I think you should go up.
So you can see me? I am average height for women, by the way. I checked. All right. Well, thank you very much, Jason. You really put together an interesting dilemma here for us. What's really interesting about this question here is the way that we have certainty over things where typically there would be uncertainty and there would be debate. And by assuming that that certainty exists, we can start to look at whether or not certain things that we can now isolate should be driving the decision one way or the other. And so even though that's sort of a very stylized hypo that's different from the real world in that way, I think it's really useful because that can really help us figure out, articulate where we're coming from morally, ethically, legally. I think that since this is presumably an agency doing the permitting, the first place that the agency is going to have to look is at the law, right? So there's going to be potentially a federal statute that's going to be relevant to this, presumably state agency. There's certainly going to be a state statute that created the agency, and probably lots of other relevant statutes too. So it may be that the statute is going to answer this question for us. It's going to tell us that we only need to use a certain technology, and if that technology is in use, then the permit should be granted. Or maybe that statute will tell us that we have to be absolutists, that we can't accept any risk of harm whatsoever. So it's possible that that's what our statute does. It answers a question for us. And since we live in a democracy, we're gonna follow the laws. We're not gonna be little dictators deciding, well, actually, I have a preference for this approach, so that's the way it's going to go, right? Not all agencies do follow the statute, but this is I think where we should start, right? If that doesn't answer the question, and here we have a hypothetical where it doesn't, right, where we're stuck with this dilemma where the agency presumably has a discretion to grant or not grant, then Jason has given us an example where we can really see the risks of not allowing industry at all, right? You can see the risks laid out. We're going to lose this number of jobs. We're going to have this bankruptcy for this town. So you can see that a hospital is going to shut down. So you can see that there are all these social problems that are going to follow if we don't allow the pollution. And we also have this known risk. So we have this average of, one incident a year where he made this very dramatic, a baby is caused to suffer for like 30 years and then die or something. So it's pretty horrible. So you have this combination of a nearly bankrupt town, a hospital that's going to go out of business, people that are not going to have basic services in their house. But then on the other hand, you have a virtual guarantee that about once a year you're going to cause this horrible thing to happen. This is very different than what an agency normally has, right? Because your permittee is telling you that this isn't really going to happen to the baby, and there are going to be 3 times as many jobs, right? So this sort of certainty isn't what you would normally face. But you know, taking this, accepting this as the question, and accepting that the statute isn't answering it for us, what do you think? First of all, I want to hear from people out there, since nobody can represent the interests of the babies that haven't been born yet, that are going to be put through this, whose job is it to represent those interests? And to what extent is the agency obligated to consider these people that don't exist yet, that are going to be suffering as a result of this permit? So anybody, maybe stand up if you don't mind so you're heard on the mic.
Well, I won't stand up.
All right.
But I'll get it started.
Thanks, Betsy.
Well, I think that from what we know, the way agencies and their authority and their statutory authority and their grant of authority from EPA to manage the federal programs in this state, it would seem that, you know, the starting point would be looking at whether or not what the plan is proposing under their permit application is allowed.
Okay.
I mean, I don't think that you can take into consideration so much of these other things until you look first to see if somebody else has already said this is a regulated activity, and now let's take a look at what they're proposing to see whether it falls within our guidelines.
Right, and I think that it's a hypo that we want to resist, this idea that the agency has this discretion, because it seems really different from what actually happens in real life. But the idea is to try to tease out this question of if you have discretion as, you know, an administrator, and sometimes administrators do have discretion, how do you take into account these competing interests? And I agree with you that I want the statute to govern to the extent that it possibly can. So this is a very stylized, unrealistic hypo, but sure.
Well, it would be a statement against my own self-interest if I said that the agency didn't have or had more than broad discretion, or, I mean, I think that, you know, that is a very probably risky area to be in, is this in-between hypothetical that you proposed.
Well, it's presented as a hypothetical, but I can attest that our agency went through really this exact scenario back in 2011. How many people remember the blue-green algae bloom of Grand Lake? Essentially, it started at Grand Lake, which is a lake that we control, and ultimately it spread throughout the state. But at the time of the bloom, it was the largest bloom in Oklahoma history, essentially, that anybody had seen in the state, as well as it was the most toxic bloom that we've had in the state of Oklahoma. And so we kind of went through this exact scenario because as the agency in control of Grand Lake, we had the obligation of determining whether or not we needed to make some management decisions on the 4th of July weekend, one of the busiest holiday weekends for Northeast Oklahoma and Grand Lake. They say 3 weekends a year, Grand Lake becomes the 3rd largest city in Oklahoma. And at the time we were analyzing these results that we were getting back from blue-green algae, what type of species we were dealing with, what type of toxin levels were out there in the water, we had to make a decision as to whether or not we needed to have an emergency board meeting and decide whether or not to close Grand Lake over the 4th of July holiday weekend. So that's a real-world example that our agency had to go through. And with Grand Lake, it was, you know, things seemed to move at a very fast pace. And I remember getting off the phone with DEQ after we had just finished discussing the toxicity results that we had. and making a decision that we needed to contact our board and hold an emergency board meeting in Tulsa to discuss just that, whether or not, what type of limitations do we need to impose just ahead of the 4th of July weekend. And that decision was made sitting there in my office, and literally it wasn't 5 minutes after I'd made my initial phone call that it popped up on my computer screen from, I believe it was News on 6 Online, says GRDA is considering closing Grand Lake for the 4th of July weekend. And that happened literally within 3 to 5 minutes of us making that decision and making that phone call in the office. So it's presented here as a hypothetical, but we actually went through it in 2011 and had to balance the threats that we were dealing at the time, and GRDA and my office in particular was highly criticized over how we handled that situation and its impact on the local economy over the 4th of July weekend. So it's very applicable, I would think, to this discussion.
Oh, so I feel we then make that type of decision all the time right now. So because we then allow a certain amount of air pollution all the time as per the permit states, and we pretty much know that certain people die from that amount of air pollution. So we then make that type of decision all the time, really, right? I mean, because like, for example, arsenic in the drinking water and coal particulates and the entire smear.
What I like about this is really different than the way, for example, federal regulatory agencies make decisions on issues like this, is it lays out all of the details in a way that makes sense and is easy to understand. And what you'll often see from the federal regulatory agencies are, monetizations of these as streams that occur through time. And so once these things turn into dollars, so, they'll figure out how much the life is worth. They'll value the suffering too. So they may put some monetary value in the suffering. So ethically, very contentious area, this issue of monetizing all these things. But need is absolutely not the word that I want there. They want to have a way to make these decisions in a way that feels objective, to take these ethical questions and turn them into some sort of, evaluate them in a metric that makes sense. So they've taken cost-benefit analysis, which used to be very popular for Army Corps of Engineers, dam projects, to justify them, became the way that the big federal regulations were evaluated. And in order to do that, they would take all of these things, except for the jobs, which they assumed didn't matter. The assumption with jobs is that we have a labor force that is efficient, so that if you lose a job here, those people will find jobs somewhere else. So jobs weren't handled in the analysis, but all of these other issues here were inputs in the cost-benefit analysis, and they get some dollar figure. A huge problem is figuring out what to do about the people that don't exist yet, about the people that are going to be hurt in the future, because we need not just to put a dollar value on their lives, but to assess their present value. So if I knew I was going to get $1 million in 30 years, we could figure out how much that's really worth, that guarantee of money. But this is currently being done to human lives in the environmental regulation context by the federal government, and this is extremely controversial. And the question isn't whether we should discount the value of their lives. The question is, what rate should we use? I mean, there's no real traction for the view that it's illegitimate to discount these lives, not because it's not correct, but just because the debate has moved on. It moved on a long time ago. So the people that have been advocates for this have never been able to move the federal government off of this. What do you think about that? What do you think about the idea that we consider somebody who dies tomorrow as being worth a lot more than somebody who will die in 30 years? You think that's appropriate, not appropriate? How do we handle them as we make decisions? These future people or future harms.
I might chime in here. Sounds like you're trying to attribute a financial value to an ethical decision.
Oh, I'm not. I don't agree with this. I'm just describing what's done by the Office of Management and Budget.
Speaking from a regulator, working for a regulatory agency, really, when you deal with an ethical standard, the bare minimum ethical standard is compliance with the law. And then above that, you can consider a higher standard. But compliance with the law is what a regulatory agency is all about. So we're restricted to our jurisdiction, just like a federal government agency would be restricted to its jurisdiction, as defined by statutes and the rules. So the thing is, within that realm, we're limited. So we're limited to what the statutes and rules allow us to do. And if the bare ethical standard has to do with complying with those laws, I guess when you take a look at what you would do beyond that, you'd have to think about what I would do working for a regulator if I was presented with a process so broad as that, but one that might affect the life of future generations in the realm that I work in, the oil and gas industry. And I would look at the facts and evaluate the evidence and propose possibly a waiver to the rules or a waiver to the statutes. That's what agencies do when they look at a situation where the fact pattern is such that the rules themselves don't quite compass it. Something more needs to be added. So you hear the case, prepare a waiver, and then act accordingly. I don't know if that answers your question.
Well,
Definitely
sure.
about human life, but I think it might give you some perspective on the limitations of an agency.
Well, EPA right now is doing this. So EPA, this federal regulatory agency, is assigning, because OMB gives the numbers to EPA that they have to use under an executive order. So when it issues its Clean Air Act standards, even though they're not allowed to use cost-benefit analysis to determine the right choice, they still have to do the analysis. And of course, this may push them toward choosing the more cost-beneficial option. So the discount rates they're using now are 7% and 3%. So at a 7% discount rate, saving one life today is worth more than saving 10 lives in 35 years. That's how the math works out. So right now, EPA is doing this, and it's not technically supposed to drive the decision for most regulations, but it's very difficult to say, here's our regulation, we made our decision based on the statutory mandate, and by the way, it creates a net social welfare loss. It's not cost beneficial. So by choosing these numbers that are high or that create big results over time, it has this effect, I argue, of ratcheting down the stringency of regulations, even where, as a matter of what the statute says, it shouldn't be influencing their decision because they have to prepare the analysis. It may be. Other agencies and the EPA under the Safe Drinking Water Act can use cost-benefit analysis to set the standard. But sometimes they're constrained. And I'm at time, and I have to actually excuse myself, so I'm not leaving in protest to anybody's ethical views, but actually have to take off. But thank you all very much.
Thank you. So what question do we want to take up next?
Number 4. Oh, the regulations. Well, I'll take that one.
Yeah, right on.
I can just talk from here.
We'll probably take the podium, I think. The mic, I think, will be a little better.
So the question is, why is there a difference in regulation between the oil and gas industry and the construction industry on erosion control requirements? And then there's a part 2, to the extent the difference is based upon amendment to federal law, which it is there a reason basis for the difference? Is there a difference? Is the difference in regulation fair or unfair? Well, that's the more tricky question, but I can talk to the first two. Prior to 2005, under the Clean Water Act, the
the oil and gas industry was kind of left alone to do its own thing. And then in 2005, a controversy occurred, especially with respect to regulating the drilling of a well, the preparing of a well site, putting in leased roads, and constructing pits. And there was an element of the regulatory community that wanted to see that regulated at the federal level under the Clean Water Act. And a lot of debate, a lot of argument occurred, and the end result of it is that it's not. So there's no NPDES permitting for oil and gas installations like there are for other construction sites, or stormwater permitting for other type of operations. Oil and gas operations have their own set of standards that they go by. So that kind of explains the history on why that occurs. Now in Oklahoma, oil and gas operations are regulated through the Oklahoma Corporation Commission. And you can look at Title 52 to see the body of law that encompasses that Conservation Act related to production of oil and gas. Now the Corporation Commission also regulates underground storage tanks, and if you want to look at our rules, they're in Title 165 of the Oklahoma Administrative Code. So maybe that gives you a little flavor about how oil and gas operations, by the act of the legislature, have been kept separate from many other industrial and land use activities.
You may not want to answer the fair or unfair question.
Well, I may not. I don't know.
But how about the reason basis part of it? Do you think there's a reason basis between treating oil and gas installations differently, the construction on them differently than, say, the construction that takes place in a development?
Well, I think it came down to the fact that an oil and gas operation is a really unique beast. You have, say, a 5 or 10 acre site that you're trying to marshal all your resources on to extract minerals from the ground. And in that site, there are a lot of activities that have to occur that are unique to the professionals in that industry. And I think they wanted to, this is my opinion now, but I think that the industrial community, the oil and gas community, thought that they could regulate that better than under a general permit that might apply to all of these other type of construction activities that occur. And you know, there are differences between, a lot of differences between an oil and gas operation and, say, building a house or constructing a road or putting in an apartment complex, for instance, where you have to do earth moving and site prep. The main consideration, in my opinion, of those type of operations are surface runoff. How are you going to handle the sediment load? How does it affect surface waters of the state or the nation? But oil and gas operations, that's only a part of what you're concerned about. You're also concerned about the groundwater and about the production of deleterious substances. Now, I will say that one little exemption from the exclusion of oil and gas operations under the Clean Water Act have to do for those oil and gas operations that are known pollution sites. If you have an oil and gas operation where the wells are purging and it's already polluting the waters of the state, well, then you may have, as part of your compliance effort, put together a preventative runoff prevention plan for the future. Does that help at all?
Yeah, it does.
I think the real answer is that oil and gas operations are distinctly and uniquely different than normal construction operations that would be covered by general permits and laws. And the other thing to consider about oil and gas operations that's unique about them is they're like a mining operation. The substances that come out of the ground are deleterious. They have to be handled very carefully. You know, salt water damages crop capacity and also disturbs the carrying capacity of soil for promoting growth and other beneficial activities. Some of the elements in brine that come up with them are heavy metals or other type of substances that can be considered deleterious. And then there's the oil and gas that needs to be captured, and the emissions to the air around the well too that have to be considered. So I think, and I'm not speaking for the wisdom of Congress, how would I ever know that? But what I'm saying is that, in my opinion, I believe they're kept separate because it is a distinctly different and unique industry that has its own body of specialized knowledge and regulation. And you can get a flair for that if you look at our Oklahoma Administrative Code in Title 65, as I mentioned, and in Title 52 of the statutes. How have I done so far?
Doing great.
Yeah. Now, the other part of it,
Fair or unfair?
fair or unfair?
And you can pass off on that if you want, given your position.
Well, no, I'm going to go ahead and take a stand at, I'm close to retirement. And I'm fully vested. So. I believe, in my opinion, the oil and gas industry always tries to be fair in the current regulatory climate that we live in. They want to be, in my opinion, hearing thousands of cases before me as an administrative law judge. The vast majority of the people who come before the commission, in my experience, are trying to be good stewards of the land and not just engage in activities that would be unlawful. Now, there are exceptions, of course. So I think that keeping the body of law separate, as long as it achieves an equivalent level of protection of human health and the environment as having a general encompassing of all the law together, is really the answer as to whether it's fair. If it protects human health and the environment to the same level or better, then it's a fair regulatory approach. Okay, so.
David, question.
Yes, Scott.
How many inspectors do you all have?
Not near enough.
Right. So given the spatial extent of the oil and gas industry in Oklahoma, what percentage would you calculate is actually monitored in any way, shape, or form?
Well, I'm just a judge, so I don't know the personnel, but I know we don't have enough. We just don't have the resources. And everyone at the commission, it's a common topic that we wish we had more resources. We wish we could hire more inspectors. Because the volume of growth of the oil and gas industry in the last 6 years, especially due to horizontal drilling, has really gone up.
So my concern, obviously, as a citizen of the state, is from a water quality perspective. And how are we monitoring, given the variance on the Safe Drinking Water Act that was enacted by Congress, how are we monitoring these areas for determination of whether or not there's contamination?
Well, I guess from my limited perspective as an administrative law judge, I would only know the answer to that with respect to the pollution cases that come before me. I don't see a whole lot of pollution cases in my practice. Real answer would be, from the administrators themselves and how stretched their resources are and how much work individual people have to do in their inspecting duties now, I think. So that's my lawyer's wiggle answer there.
Thank you.
Yes, sir.
I guess to try to answer that second question about whether or not there's a reasons basis, you felt like there's a real difference between oil and gas construction and then permanent construction. And so I kind of wanted to force you to answer the harder variant of that, where assuming that it's not different, that they're exactly the same, and without having to define reasoned basis, if the difference in the law is a matter of federal statute, I mean, does there have to be a reasoned basis? I mean, or can the legislature make different rules for different activities, and that's fine as long as they do it? And then, I guess, in trying to answer that last question about whether or not regulation is fair or unfair, I mean, do you feel like that's dependent upon the substance of the rule, or is any rule fair provided that it's passed, according to the procedural rules for passing the statute? I mean, that's the basis for the difference. I mean...
Well, if you mean let me see if I can understand. First of all, you can't make the assumption that there are no differences. So in the real world, there are differences. They exist, so they have to be dealt with. In my opinion, that hypothetical is not so useful. But moving on to the other area, if you're thinking in terms of whether something is fair in terms of our Constitution, well, we all think in terms of whether an administrative action is arbitrary or capricious. That's the standard that regulators look to in terms of fairness. Is that what you're getting to, or have I missed the question totally?
Well, I guess I was really wanting to just think about, in trying to figure out whether something's fair or not, and if the difference is based on what the legislature voted on. I mean, isn't the legislature then deciding, what the rules are? And if to the extent something's, don't they decide what's fair or unfair? I mean, how would you, for that question to have meaning, I've got to have something apart from just the legislature, even if it's exactly the same, even if the legislature passed a statute that said, hey, car washes don't have to pass, don't have to get these permits. They passed it. does it matter whether or not they had a good reason for exempting car washes and not exempting something else?
Well, let me stab at it. I'm certainly not one to speak to whether or not legislative action or their deliberation were made based on fairness. I don't know if they are or not. I think you can only interpret whether something is fair other than a constitutional test. That's done in the process of making a law or having a hearing and the process of bringing a law into promulgation. I think the only way you can determine if a law is fair or unfair is by the results of it. Now, if the results of it achieve fairness, then you can say, well, I guess the law was a fair law. If it turns out to create an unjust result or an inequitable result, then you can conclude that it's not been fair. That would be my analysis. Yes, sir.
David, kind of boil down a little bit what Scott's saying. I think some of the cause for concern, the difference between the two, is sediment from a stormwater construction site. Traditionally, sediment is a pollutant, and that's the main pollutant.
Right.
And that's what the permits are trying to regulate and contain. From an oil and gas site, Congress, for whatever reason, or EPA through their rulemaking, has said sediment's not a pollutant, and therefore stormwater permit's not required unless there is a deleterious substance coming from the site. So how on one side can you say sediment's a pollutant, other side it's not, and then you have a difference in the permitting standards?
Well, there's a rub, isn't there? You know, how the federal legislature determines their actions is often a mystery. The thing is that under our body of Oklahoma state law, we consider sediment to be a cause of pollution and it needs to be controlled under the statutes that we have. Any other questions where I can muddy the water further?
David, I want to really congratulate you. You did a beautiful job resolving on some of this.
Muddying the water?
No,
yeah, thank you.
I've got to give a perspective.
Okay.
Thank you for letting me stand up for just a minute.
Are you going to yell at me?
No, I'm not going to yell at you. I come to it from a different standpoint. And I agree with him on the one thing. When you go to work every day in your private sector jobs, you can do anything you want to do unless the law says you can't. When I arrive at my office and the other state officials that are here arrive at our office, we can't do anything unless the law says we can. So we have to put that hat on. We are bound by the law, but thinking back, the Clean Water Act was passed in 1972. The National Wild and Scenic Rivers Act, which I'm the river guy, was passed in 1968. It predated the Clean Water Act, and in the 60s, our country started coming to aware of our environmental problems. Excuse me, folks, if I look swollen. I've got this dreaded swelling going on. I don't know what it is. It's been happening the last couple of weeks, and so anyway, lip swells or an eye closes, just keep listening. My job's to speak. Your job's to listen. You get through before I do, you can leave. But the National Wild and Scenic Rivers took a comprehensive look at our 10,000 rivers that make up these United States. Now, there's more rivers than that, but rivers that you can say, look at a road map, say this is a particular river like the Illinois. And Congress said we want to set aside a certain number of these rivers to protect them. We started doing that, so I've got probably the longest tenure here at the podium as far as environmental regulation. The Clean Water Act just passed in 1972, and it said that we'd make all of our waters fishable and swimmable by 1984, dealing with point source pollutants. Those things we could go and say, discernibly, this is where it originated, this is where it came from. Within the Clean Water Act, though, it said non-point source pollutants will be left to the authority of the states to deal with. Everybody agree, stipulate to that? We really haven't, as a state, or for that matter, as a United States, really started dealing with non-point source pollutants until the late 1980s. And they are just now coming of age, and the reason that there's a difference is because of political and money issues and a lot of these things that we're dealing with regulation-wise. The cities are taking, the urban areas are taking, and the industry is taking the brunt of most of what came out of the Clean Water Act because it addressed point source. We're just now getting around to addressing non-point. Animal waste issues that you've seen me on TV and talking about, oil and gas is in the same arena. We're just now coming of the age, and we're just now becoming of the understanding. We know exactly what the ramifications are, or beginning to suspect what the ramifications are to our environment. So that's why there's a difference. Those people that live in the urban area, they're low-hanging fruit. It's easy to see what they're doing and to respond because the majority of the population lives there. The most people who speak up generally are the people who get the rules and regulations made for them.
You've heard from a lot of different sources here today, and one source that you haven't heard from is an in-house governmental attorney. And you've heard from a judge, you've heard from some of these others, but I have a rather unique experience. Before I get started, I want to make one remark, or what I call my normal disclaimer, is that the comments that I make, the opinions I express today, are those of me and me alone. They do not necessarily represent the opinions of my client, the Oklahoma Department of Mines, or any individual employee that works there. So if I say something that disturbs you, that upsets you, that you think is just incredibly stupid, and I probably will, then please, when you start your emailing and letter writing campaign, don't blame my client. Blame me. You can call me any name you want to. It kind of reminds me of a case. I was forfeiting a number of bonds on a coal operator a number of years ago, and several $1 million worth, as I recall. And I ran into him in the hallway during the legal proceeding, and I have to watch my language here. I can't repeat what he said, but it's synonymous with crappy. And I said, well, you know, you're probably right, and went on with it. But I've been called a lot of things, even recently. Been called intimidator and a few other things. I think Jason might be aware of those comments. Yeah, I'm aware of those comments. But anyway, discussing this factual pattern that we're here, obviously that's not going to happen. You're not going to have a black and white case like this come before the agency, and when the agency attorney is required to represent his client's decision, and the term arbitrary and capricious came up here, and that is one of the few areas where you can get an agency decision overturned on appeal. When I first came to work with the department, we got hit with 3 lawsuits in the first week, and each one I kept turning page, arbitrary, capricious, arbitrary, and I thought, well, I better find out what this term means, because I hadn't got a clue. And I learned rather rapidly what it is, and it certainly is. It's under the Administrative Procedures Act, and on appeal to district courts. They can't substitute their own opinion for that of the agencies unless our decision is found to be arbitrary and capricious. They can look at legal issues de novo, of course. And so one of the questions that I run into as an in-house attorney is that we eat, live, sleep, breathe the areas that we regulate. That's what we do every day we come into work. And it's inevitable that we are going to have and develop some personal opinions regarding not just policies, but maybe interpretations of regulations that we enforce. And those may not be consistent with the opinions of our client. And
you're addressing question 3.
Yeah, well, 3, I'm kind of segmenting into 3 because I wrote that question. I want to talk about it. So you have to, basically there's one of 3 things you can do, which is you can either put your own personal opinions aside and represent the interest of your client. You can communicate with your client and try to convince them that maybe the error of their ways, that it's their position is not in the best interest of the agency. Or if it's something that just really rubs against you and you just can't live with it, you can go look for another job. Those are essentially the 3 options you have. But I thought rather than standing up here and giving you a bunch of ethical rules to no one's going to remember 5 minutes after I talk about them, I thought maybe the better course of action would be to give you some real experiences that I have been involved with in my 26, 7 years with the Department of Mines. I think those make more, I can convey the point I'm trying to make a little easier that way. The first case involved a number of years ago. And it was a surface coal mining case. I think the operator had submitted an application for either a bond release or revision. I think it was bond release. And the landowner of the property had filed an objection. And we had a formal administrative proceeding, individual proceedings defined under the APA. And they had counsel, and the company had counsel. The department really wasn't involved as a party in this thing. We were more acting as a court because we're required to make a decision on these things. And I don't like to talk negatively about other attorneys. There's one exception, I'll get to him in a minute. But there's this attorney that was representing the protestant really was not competent. And she really wasn't serving the interest of her client. And at the end of the day, the hearing examiner upheld the decision of the department, which was to approve the bond release. And in our law, under the Surface Coal Acts, there is a provision that allows for the award of attorney's fees to the prevailing party if you can establish that the cause of action was brought frivolously. Well, the coal company filed an application with the hearing examiner for attorney's fees. He denied it, and sometime later I was discussing the matter with him, and he said, you know, Mark, he said, I really wanted to grant that, but he said, I just didn't feel like it was appropriate to essentially penalize the protestants for the incompetence of their attorney. And I agreed with him very much so on that issue. The decision to deny the attorney's fees award was appealed to the director. And let me be very clear about this. This was a different director than what we have today. And his decision, after he reviewed the record and discovered that the objectors had admitted that they had told the coal company that for $200,000 they would disappear. And this just rubbed him wrong, and he says, I want to award those attorney's fees. And I said, well, I can't agree with you on this. I said, I agree with the hearing examiner that this is really a punishment of the protestants for the conduct of their attorney. I think beyond that, it would have a chilling effect if this got out that this agency has a policy or routinely is awarding attorney's fees against people exercising their due process. And I said beyond that, at that time we were having some difficulties, still are, with a federal oversight agency, and this was certainly something that was going to make that situation even worse. And he says, he made up his mind, I don't care. And so I said, well, we'll draft the order up for the agency, and I knew it would be appealed to district court. It was LaFleur County. And my own personal hope is that the decision of the department on the bond release would be upheld, because I thought it was they had met the requirements of the law. But I was really hoping that district judge would overturn the decision of the department to award attorney's fees. He did not. He upheld it, and that's not something that, you know, this is a situation where I had to choose one of those options. Either I could have left over it, or I could represent the interests of the agency. Actually, on that appeal to district court, we were a nominal party only. I did not file any legal documents. I informed the judge, you're not going to see me on this case. And it was basically between the protestant and the coal company. The other case I'd like to tell you about happened very recently. And this kind of thing is so convoluted and complicated, and there's a long history behind it. I'll try to make it short as I can, but there is a federal agency that oversees the department's enforcement of the Surface Coal Mining Acts and their division of the Department of Interior. And one of the requirements when you mine coal is that you restore that property in your reclamation to a term that's called approximate original contour, AOC. And if anyone in here can define for me what approximate is, would you see me after this thing? Because it is a very squeaky type of concept that everybody has a different opinion about. And the case law on it is all over the place. Basically what they say is it's not elevation. When you mine and move a lot of dirt, you're going to change the elevation because you're going to have a swell factor out there. And this particular mining company has a habit of leaving final pit impoundments, which are legal if they're approved by the regulatory authority. And we had approved what was left out there on these sites. And they're rather large. Of course, the material that would normally go back to filling that hole has to be respread out over the area of the permit, which is going to increase that swell factor even more. So years after the permits and the revisions were approved by the department, and years after most of the reclamation had been completed, this federal agency came down and said, look, you've got to, the company, you've got to reclaim this in a whole different standard. And needless to say, this is a humongous economic undertaking for the company. And they appealed this decision through the federal administrative procedures and had a hearing. We weren't a party to it, but a number of our employees were subpoenaed to testify. And during the testimony, the federal attorney who was cross-examining one of the employees of the department, who had a history, a very vocal history with my agency and with me personally, regarding whether or not we were properly interpreting this AOC requirement, discovered on cross-examination that there had been a meeting that took place between the Department of Mines and his client shortly before this hearing, and for the first time, the federal agency had indicated to us that they would actually consider a program amendment. That is a change in our regulations in the coal area. But heretofore, this attorney had always taken the position, our law read identical to the federal law. All we needed to do was change our policy on interpretation and go on. Well, you can't enforce by policy. You enforce by regulation if you're a regulatory authority. If you try enforcing by policy, it's a ticket to getting overturned on appeal every single time. General rule of thumb that I like to follow is if what you're attempting to do affects the people you regulate, you better have some regulations to back you up or you're in for a long haul in court. And so we had always taken the position, we will accept in the review of this new concept, this new interpretation of AOC, going forward on the condition that the federal agency approve a program amendment that had more specifics that would allow us to look at it the way they were looking at it. And it came out during this cross-examination that a meeting took place and that the federal agency, a representative of the federal agency, had actually indicated to us for the first time that they would consider that program amendment. And I don't know whether this caught him by surprise or whether he was anticipating this, but immediately proceeded to question the witness if she knew that this individual for his client had the authority to speak for his client. Well, this individual happened to be the acting director of the field office in Oklahoma. And his boss was sitting in the room and came up to the director of the Department of Mines and said, I can assure you that this individual speaks for this federal agency. And he did it through clenched teeth. He wasn't a happy camper. I guess the moral of my story is that if you are an in-house counsel, you need to be sure that you don't put your own personal opinion or agendas ahead of what's in the best interest of your client. If you do, you probably ought to go somewhere else, and it's just not going to work. You're probably going to be asked to leave in a minute if you do. Anyway, if you got any questions, I'll try to answer them. No, that's about all the time. All right.